Oh,
I'm having a technical difficulty. How do I do
okay. Well, we're streaming, so be careful what you say.
Yeah.
But we're not on the record yet. Computer's acting up this morning.
What's going on here? Why can't I get out of this?
Oh. There should be a minimize
I know.
up there. Go from the right. See that? Nothing's happening?
Okay. I don't know what just happened. Well, okay, regardless. Okay.
We are on the record in the matter of Dakota Patrick et al. Versus Herschel Bailey et al. Mr. Corey McCord here on behalf of the plaintiffs. This is your motion for entry of a default judgment quieting title to a mobile home, I believe.
Correct.
You know, it's interesting. A friend was charged with settling his sister's estate and ran into the same problem. And apparently, there's been some kind of change in the law. I remember years ago, if you put a mobile home on real estate and attached it, it became part of the real estate. But apparently, that's not the case anymore.
No, the Secretary of State used to allow the title companies to come in and basically apply for a lost title. And they were sued in federal court by a bunch of the mobile home parks. And so they just stopped doing that probably about a year ago.
Well,
there's some legislation pending to fix it, but I don't it hasn't moved forward at all. So.
I know it created a significant delay for him in selling the property.
Yeah.
Because they weren't able, and I can't remember, a former spouse of his sister was still on the title, or just it was a real ordeal getting it fixed.
They become a real mess.
There's no defendant has appeared in the action. They've been defaulted. No one has appeared today to oppose your motion for entry of judgment. I'm going to grant it in the form that you submitted.
Very good. Thank you, Judge.
You are welcome. We'll see that a copy gets forwarded to you.
Thank you so much. Have a good weekend.
Thank you. You too. So let me fix this. Actually, could you move over one chair? Then I don't have to mess with this at all.
Yes, not a problem.
It's kind of touchy. It doesn't want to move and it doesn't want to move. And then eventually it jumps all the way over to the jury box. So I'm not quite sure what the problem is, but this will work good. And let's see, Mr. Williams is in the waiting room. Good morning. This is a matter of Rendell versus Jackson Crossing Realty et al. And we're here on the plaintiff's motion for spoliation of evidence. Mr. Jennings for the plaintiff, Mr. Williams for the defendants. Go ahead, Mr. Jennings.
Good morning, Your Honor. Thank you. Chris Jennings appearing on behalf of the plaintiff, Chris Rendell. This motion has two components, really. One of them is the spoliation of evidence. The second one is a motion to strike pleadings and or compel more specific responses to discovery.
So on the spoliation, I read through what you submitted. It sounds like you're speculating that there might be another video out there and that somehow the defendants have control over it. Do you have evidence that that's true?
Well, so the evidence that I have, Your Honor, is defendant's responses to written discovery that were signed by Mr. Williams and by the general manager, Alfie Kane at the mall. And if you look on page 2 of my motion, I provided a screenshot of the surveillance footage that was produced. And I'm not saying that it wasn't produced. We have that Bed Bath & Beyond gave us the 10 minutes of video. That's a screenshot of the video footage that was produced.
Okay.
Defendants answered discovery and stated that the video surveillance that they observed or they watched shows that their wet floor signs are in place. If you look at that whole 10 minutes, that camera doesn't move. That's the only view that you have of that video from this particular camera. So for them to say that they watched video that showed the cones were in place means they must have watched video from another camera.
I gotcha. So either they failed to produce video from another camera or their responses need to be amended. So
one of the two. One of the two. The only issue really with this, though, Your Honor, is
when they said they watched video footage, were they specific in the response as to what video footage they watched?
all that it says, the video from Bed Bath & Beyond shows that our wet floor cones were in place at the time of the incident.
And you've watched the video and it doesn't show that.
That's correct. And here's the real issue, Your Honor. On July 18th, I sent a preservation of evidence letter to Alfie King.
Yeah, I saw all of that.
So if they watched the video,
if they watched the video and
they had
didn't
an
preserve it, right?
And
so let me ask Mr. Williams. Okay, so
Sure.
If your answer says the video shows the cones were in place, and the only video that exists that's been produced shows that the videos that the caution signs aren't in place.
Here's the issue, Judge, and it really goes to the core question that you asked Brother Counsel initially, and respectfully, I think he sidestepped your question to him. You wanted to know if he has any evidence that my clients have possession and control over this video. You may recall we've been over this before when we were here for the last hearing. You directed plaintiff's counsel to reach out to non-party Bed Bath & Beyond about any video issues that they may have. My clients never possessed or controlled any video of this incident. They've been clear about that from the very beginning. What we did is we facilitated communication between plaintiff's counsel and non-party Bed Bath & Beyond, their corporate office. They were talking. That's what you directed plaintiff's counsel to do, is to take that issue up with them about the video. The representative from Bed Bath & Beyond, whom I do not represent, Your Honor, indicated to both myself and to plaintiff's counsel that the only video that's available that they have has been produced. That's the video that I have. That's the video that plaintiff's counsel has. Now, if plaintiff's counsel has watched that video and he disagrees with what my client, Alfie Kane, says he saw when he watched a video of this incident, whenever that was, pre-suit, that's not grounds to indicate that my clients have destroyed or intentionally withheld video. They've indicated that they never had it, all right? So what he's asking the court to do here is, one, he's ignoring your prior directive, which was to take up any issues with this video with Bed Bath & Beyond. After you instructed Brother Counsel to do that, he's done nothing that I've seen. I haven't seen any further communication from his office to that corporate rep from Bed Bath & Beyond. Rather, he's continuing to try to place that burden on my clients when Your Honor already told him who to take the issue up with. That is the issue.
All right. So the representative of the defendants who signed the discovery responses and said, I watched a video that shows the cones in place. Has he been deposed about the video?
No. They haven't requested his deposition, Your Honor, and what they're asking you to do here is to essentially weigh the credibility of a witness, and they haven't even taken his deposition. So with all due respect, plaintiff's counsel disagrees with my client's personal observations or his knowledge of the case, and he's asking you, because he disagrees with that, to rule that my client spoiled evidence.
So, Mr. Williams, you viewed the only video that Bed Bath & Beyond has produced, correct?
The same video that plaintiff's counsel had.
Do you agree that nowhere in that 10-minute segment do caution signs appear?
The video admittedly is grainy that I viewed. You can't see, I can't see what's outside of the entrance, the mall entrance doors there. But if Alfie Kane viewed that video and that's what he believed that he saw when he viewed the video, that's on him. Whether or not Your Honor or plaintiff's counsel or even I agree with what he believes he saw, that's an issue for his deposition. If it's a credibility issue, so be it. That's what he says he remembers seeing when he viewed that video.
So,
but he never possessed or controlled that video.
So, Mr. Jennings, it would seem to me that before I can rule on this motion, which yours is based on essentially a logical sequence, that I understand where you're coming from, but until you depose this witness and you ask him, or you find some other way of asking him other than a deposition, is this the video that you viewed? And we've looked at the video. We don't see any cones. Can you point out to me in this video where those cones are? And if he says, well, it must have been a different video that I saw, wouldn't that then be a video, since he says the video he saw was a Bed Bath & Beyond video, isn't your beef with Bed Bath & Beyond to produce another video?
Well, it is, to the extent that Alfie Kane and Jackson Crossing and the defendants were never involved in this. But if Alfie Kane, the general manager of the mall, watched a video that included the wet floor signs, and he didn't take any steps to preserve it or ask for that video, then how can I depose him and having a full understanding of knowledge?
Wait a minute. Preserving what they have possession and control of is something that they certainly have an obligation to do. Obtaining and preserving from a third party, where does that obligation arise from?
So Mr. Kane, there could be a ton of other videos that Mr. Kane watched, and he has knowledge from those videos, and he's going to come and testify about what he observed in those other videos, but I never get a chance.
Not very effectively. Not very effectively. When you put on somebody when he says it was a Best Buy video, isn't that what he said?
A Bed Bath & Beyond video.
I'm sorry,
lots of
Bed
Bs.
Bath & Beyond, too many B's. Sorry, they're both in the same mall that I go in about once every other year. So if he says it was a Bed Bath & Beyond video and he saw cones in it, and a Bed Bath & Beyond representative says, this is the only video we've ever had, this is the only video that he could have seen, then it's just, he's lost credibility completely. Where's the spoliation issue? I just don't get it.
Well, I think that
Your Honor, if I may, oh, go ahead. Sorry, Chris.
I was going to say that there's more issues going on here as well.
I get that, but the spoliation with respect to the video, I don't see it.
Right. And that's fine. And maybe the issue needs to be further flushed out, and after his deposition is taken, we can readdress it, and that's fine.
I think you could have a lot of fun with that deposition, Mr. Jennings.
So in terms of the other things that are at issue in this motion, was the motion to compel more specific responses from the defendants. Specifically, the motion outlined 10 different requests for production of documents and 5 interrogatories that were incomplete or non-responsive. I'll give some highlights just to try to.
Let's take them one at a time.
All right.
Your Honor, before we even get into that, just in reviewing plaintiff's motion and the wherefore paragraph, the prayer for relief, there is no prayer for relief for more specific responses. The motion is titled spoliation of evidence. The wherefore paragraph asks this court to strike my client's pleadings or enter a default based on spoliation of evidence. There is no request for any more specific discovery responses in the wherefore prayer for relief nor in the caption of the motion.
I respect that, but if it's something I can deal with today rather than require a supplemental motion, I'm going to deal with it today. Go ahead,
Fair enough,
go ahead,
Your
Mr. Jennings.
So if I started outlining the different discovery responses.
Right. Which is the first response you've got an issue with?
Request number 2 and number 3.
All right, hold on a minute. Is that exhibit A?
Yes, it is exhibit A too.
All right, hold on. Let me go there. So number 1, you said?
Number 2 and number 3.
All right, so let me look at number 2.
And we've already kind of dealt with these because this is about the video footage. So
yeah, how they're going to supplement with
and
the
I
only
understand
video they're aware of.
and I
So
understand that. Number 5.
all right, I'm looking at 5.
So this request sought communications between defendants and any other person or entity. We know that there was communication between Namdar Equity Holding Company, who is the company who owns Jackson Mall and 60 other malls across the country. They had sent correspondence dated July 24th to Bed Bath & Beyond. We don't have any correspondence back from Bed Bath & Beyond or following up from that correspondence regarding production of the video. So we know that the video was produced by Bed Bath & Beyond. Where's the correspondence that went along with it? Where's the email communications between Mr. Williams and Corvell, the third party, record custodian for Bed Bath & Beyond that initiated this entire production of video? I've been asking for these documentation. This stuff should have been produced a long time ago. I think I'm entitled to all of these communications. Mr. Williams is represented. He doesn't represent Bed Bath & Beyond. So there's no attorney-client privilege that can be asserted here. I'm entitled to all of these communications between Namdar, the defendants, and Bed Bath & Beyond.
With respect to anything relating to this incident, Mr. Williams, do you have such communications that you haven't produced?
Well, one, Your Honor, I believe that there's 2 different things going on here. I want to be sure that we're all on the same page. So the request to produce that he's referring to is about communication between my client and Bed Bath & Beyond. Now, within the response to this motion, you'll see, Judge, that Alfie Kane, the client representative that I have here, indicates, and it's in our response, that by his recollection, the communication was verbal, okay? He also has indicated, and he'll testify to the fact that he had to go down to, I believe, the Bed Bath & Beyond location, store location, to view the video upon which his responses are based, okay? So it's not an incident where they emailed him a link or mailed him a copy of any video. He'll testify in that regard. Once litigation ensued and this video became an issue on my desk, I tried to facilitate this communication between Chris Jennings and Corvell. They said, hey, there's one video, whatever I got and they sent over, I gave it to Chris immediately. And I said, Chris, you talk to this individual. My clients have told you they don't have it. This is your gatekeeper. This is who you need to deal with. And I saw a thread. I was kept on that thread between Corvell and Mr. Jennings, wherein that individual for Bed Bath & Beyond told them, hey, the only video we have, we've produced. So to the extent that that's written communication, I can produce that. If it's verbal, as Alfie Kane is represented, he can testify in that regard if he picked up the phone and called Bed Bath & Beyond. Fair enough. I don't know.
I'm not asking you to produce something that doesn't exist. Mr. Williams, my question was simple. Other than the post-litigation communications that you just recited, do you or your client have any other written communication between your client and Bed Bath & Beyond regarding this incident?
My understanding, the answer to that question is no.
There we go.
Well, and I see this is the problem though, Your Honor. So Alfie Kane signed these answers and he indicated the only communication was verbal. Yet here we have written correspondence between the defendants and Bed Bath & Beyond.
Where did you get that?
This was from Namdar Realty Group, who is the equity holding company that owns Jackson Crossing. This was dated July 24th of 2020.
But where did you get it?
From Namdar.
So you submitted a discovery request to Namdar?
Well, pre-suit, when I sent the preservation of evidence letter to Alfie Kane, he put me in contact with legal counsel out in New York.
I got you. And what you're saying is there should be some response to that. There should be some other communication. But in any event, that was not produced in response to your document request. You obtained it from another source.
And Alfie Kane is saying the only communication was verbal. So just because Alfie Kane didn't have any other communication doesn't mean the defendants as a group or individuals from the defendants didn't have communications. I'm not just entitled to what Alfie Kane did or didn't do. Alfie Kane is just the representative that's answering discovery on behalf of the defendants. I'm entitled to all of the information that the defendants transmitted or received in regards to this incident.
So why wasn't this document produced in the discovery response that's at issue here, Exhibit A?
Well, my understanding is that plaintiff's counsel already had that. In fact, it's just a letter, Judge, that he's asking for the preservation of evidence, and Namdar's legal counsel forwarded that letter, I believe, to Bed Bath & Beyond and said, do you have any video? That's all pre-suit. And it's my plaintiff's counsel had that before this lawsuit started. Now, there's
that may be, but when you're asked to produce something, you don't necessarily know what the other party has or doesn't have. You're just supposed to produce what you've got. I mean, who knows? There might be some extraneous writing on it.
That's fair, Your Honor. And I think the logical explanation for that is the individual whom I believe Brother Counsel is referring to is House Counsel. Whoever Namdar is not a party to this lawsuit. Okay, Namdar, their general counsel or House Counsel is Josh Hackman. Okay, and Alfie Kane is the client representative on behalf of the mall. Alfie Kane produced documents that Alfie Kane is aware of on behalf of the mall. The fact that that letter, a Namdar letter that may have been signed by Namdar's House Counsel attorney to Bed Bath & Beyond was not produced by the mall in response to discovery responses. That could be a logical explanation for that. The issue can be taken up at Alfie Kane's deposition. Have you seen this document before? Did you sign it? No, I didn't. Is it on behalf of the mall or is it on behalf of NAM? I mean, there's a number of ways to handle that.
So what is, Namdar is not a party, but what is their relationship to the defendants?
I believe, Your Honor, that Namdar at one point may have owned the mall or maybe was a DBA. I think they may also be a realty company, but Namdar has its own legal counsel, Josh Hackman. I believe Chris Jennings worked, I don't want to say worked with him, but had some communication with him pre-suit. Namdar isn't a party though. The mall is a party. And Alfie Kane is attesting to discovery responses based upon his knowledge and observations.
All right. So whether or not Namdar has more communications, your representation to the court is that Alfie Kane and the entities he works for doesn't have it in his files. So Mr. Jennings, did you think about following up with Namdar to see through a non-party subpoena whether they have any other communications? And I'm assuming you communicated with Bed Bath and Beyond with a subpoena for any documents they had.
Well, so I guess
I haven't seen a subpoena.
So is Alfie Kane and Jackson Crossing Realty, Jackson Crossing CH LLC, Jackson Crossing Nassim LLC, all the defendants named in this lawsuit, are they insulated to only what Alfie Kane knows, or the other steps that other individuals may have taken on behalf of the defendants in regard to this? I don't have access to that.
And of course you've got access to it. If those documents exist with any of those named defendants and they have them, they need to be produced, regardless of what Alfie Kane might know. And if they haven't been produced, there could very well be some kind of a discovery violation. But what you're showing me is not a letter from any of the named defendants. It's a letter from another entity. You can't expect these defendants to go to those entities and gather documents for you. You got to send a subpoena to them.
All right, so in the sense that Alfie Kane responded and said the only communications between the defendants and Bed Bath & Beyond were verbal, knowing that there was this letter out there.
But this isn't communication between the defendants and Bed Bath & Beyond.
So
It's between Namdar's counsel and Bed Bath & Beyond. You don't see a distinction there?
I do, but from where I'm standing, Namdar Realty Group is an equity holding company that owns Jackson Crossing. That's who this lawsuit was originally filed against. And then Javon Williams indicated that the actual owners in Michigan were these three defendants. So should I just bring Namdar back into the lawsuit and ask them to defend and hire their own counsel?
Well, no, you don't. If you're just looking for their communications, all you got to do is send them a subpoena.
All right, we will send them a subpoena.
Same thing with Bed Bath & Beyond. And if there were communications back from Bed Bath & Beyond, I would assume you would have gotten it from them if you submitted a subpoena to them. That's fair game. That's fair discovery. But you can't expect these defendants to go out and gather documents from people who aren't parties to the lawsuit.
Fair enough.
I mean, from their agents and attorneys, absolutely. But from other unnamed entities, no, you got to request it from those entities.
So from Mr. Williams, from your standpoint, is Namdar or Joshua Hackman an agent or an attorney for your defendants?
That's a separate issue. They're separate and distinct legal entities. You're aware of that. And if you got an issue with Namdar, you know who their attorney is. But for purposes of your motion and what you're requesting here, I mean, I think that's improper. You know where to go with it.
All right, I will send a subpoena to Namdar.
That's I think your course. And definitely, if I were you, I'd be taking this gentleman's deposition and get to the bottom of what is it. You know, maybe he's got a faulty memory. Who knows? But if he adamantly states, I saw a video that had cones in it, and this one doesn't, I think you can have a little fun with that with the jury.
All right, request number 16, requested copies of documents or evidence that support the defendant's affirmative defenses. Defendant simply responded that they'll submit an exhibit list. Well, I'm not asking for an exhibit list. I want to know, and I have a right to all the evidence that you have right now that supports your affirmative defenses.
Yeah, Mr. Williams, if a document shows up on an exhibit list that's responsive to any request that you've received, I'm not going to allow its admission. It's that simple.
Judge, here's the response to that issue. We just, and admittedly in our response brief, there's a typo with regard to the date of plaintiff's deposition. We just took plaintiff's deposition, Judge. That deposition testimony, she is bound by it. I don't know if you had an opportunity to read the brief. We are pretty much a year out from this incident. She has no idea what caused her to fall down. She doesn't know. She wasn't looking at the ground when she walked into the mall. She admitted that there was precipitation outside. She came in, she didn't wipe her feet, doesn't know if the ground was wet, doesn't know if there was a hazard on the ground present. Even when she was on the ground, did not become aware that the ground was wet. She admitted that she doesn't know. if the mall had any prior notice, actual or constructive, about a hazard on the ground there. She pretty much admitted everything along the lines of her not even being able to speculate as to what caused her to fall. I asked her at 3 different intervals during the deposition, can you tell us what you think caused you? I don't know. I walked in, I wasn't looking, I stepped, I fell. I don't know if the ground was wet. I don't know if anything was there. I don't know if there were any prior complaints. Her deposition testimony supports our affirmative defenses. We just had her dep this week, I believe, Judge. Unfortunately, the transcript isn't available just yet, but Chris knows exactly what she testified to. He was there for the deposition. That supports our affirmative defenses, speculation, open and obvious, and lack of notice. That in addition to the video that everyone, well, Chris and we now have. So I don't know how he wants to handle that. He can't alter her testimony. She's bound by it, but it absolutely supports our affirmative defenses.
And I wouldn't expect you to.
And we didn't have that information when we responded to the discovery. Sorry.
Yeah, no, I'm not talking about something that got generated after your responses, but I am telling you, the deposition transcript's a little different animal, and I wouldn't put that in the category of my warning to you that if you have documentary evidence that shows up on your exhibit list and didn't show up in a discovery response, I'm not going to let you introduce it. That goes both ways. You can't wait. It's not an appropriate answer if you have documents to say, wait till I file an exhibit list. If you got the documents, you're obligated to produce it. And you don't have to produce
along the same.
You don't have to produce a deposition transcript because he's already got it.
In that same vein, Your Honor, we're attorneys here. If there were documents and information that supported my case, why would I withhold that from the other side? That makes no sense. That would be front and center, as a C8, C10 motion right off the bat. Why would I hide evidence or my client hide evidence that supports their theory? That makes no sense.
Okay, Mr. Jennings, any other of the discovery responses you want the court to address today?
We've talked about request number 23, which dealt with the communication between Bed Bath & Beyond. We've reached the conclusion that I need to send subpoenas to those non-parties. Request number 25 asks for documentation pertaining to the ownership of the video cameras that are at issue. The defendants responded, the cameras have been inoperable since the mall was purchased in 2018. Well, that's not any information about who owned the video cameras. So if Jackson Crossing owned the video cameras and installed the video cameras inside Bed Bath & Beyond, or had a right to control and access them, that changes the entire narrative about who had control and possession of the documentation.
Well, I'm assuming the response was referring to cameras other than the Bed Bath & Beyond camera, which obviously was operable. It's referring to
correct, and
inoperable cameras.
In the corridor. We actually addressed that too in our response, Judge. The fact that we're referring to cameras in the corridor that have not been operable since that mall was purchased, well before this incident occurred. It's in our discovery responses, and Alfie came to testify in regards to that. They didn't have any recording information, no loops. They never had, my clients never had possession or control of any video from any inoperable camera in these corridors. So,
a camera that's attached in the corridor obviously is a fixture that would have passed with ownership of the mall.
Well, with regard to request number 27, I asked for specific documentation relating to the installation and operating the security cameras inside Bed Bath & Beyond. Defendant's response was, defendant is searching to ascertain whether any documents relate to installing and operating cameras between Bed Bath & Beyond. So when can I expect those? Do I have to wait until after I depose Alfie Kane to get those? Do they exist? Are they not in existence?
And so
To date, that information has not been located by my client. You may want to include that in any subpoena that you're going to send to Bed Bath & Beyond, though.
So your clients own the mall and they don't have documentation or contracts about who installed those cameras? I mean, it seems like we're just going around in circles here.
I don't know what you would expect to find. I can't imagine, other than the lease itself, that there's some kind of separate agreement between the mall owner and its tenants. I mean, they don't do multiple agreements, they do a lease. And if it's mentioned in the lease, then it's there. If it's not, it probably doesn't exist. I wouldn't expect a separate agreement on that. And do you have the lease?
I do have the lease, and it doesn't mention security cameras at all.
I'm not surprised.
Which is why I thought that there might be other documentation between the mall and Bed Bath & Beyond about who was in charge of those. Moving on to request number 29, defendants asked for any and all documentation with regard to what defendants did when they received the preservation of evidence letters. Defendant's response was unknown. I mean, that's not a response. That doesn't tell me that you didn't do anything. You sent out additional correspondence. You sat there and did nothing. How am I supposed to know what steps were taken if when I asked for documentation or any steps that you took and your answer is unknown?
Mr. Williams, that does strike me as a non-responsive response. If you don't,
that's a response.
If
sure.
you don't have any, if you don't have any documents, you say we don't have any documents. You don't say unknown.
Fair enough.
So you need to amend that response.
I can supplement that. Will do.
Okay.
And which, for the record, so we're all clear, I'm sorry, which one was that?
29.
Okay, will do.
Any others, Mr. Jennings?
Number 30, if you contend that plaintiff was in any way responsible for this accident, then please provide each and every piece of information, evidence that you are relying upon. And defendants gave a very legalese response. Plaintiff had a duty to care for her own safety and to travel through the mall in a careful and prudent manner so not to injure herself. Plaintiff failed to do so. Well, this is a request for production of documents, not an answer for, legalese. So either you have documentation or you don't that supports that.
And I think, Mr. Williams, you need to supplement this response to say whether or not you have any documents responsive to this request.
Sure, we'll reference the deposition testimony.
Number 30.
Thank you.
Number 35, which was part of the motion, is again dealing with surveillance footage. So we've already discussed that. Moving to the interrogatories, which were Exhibit C to our motion. Interrogatory number 2 sought information about prior warnings. And they didn't provide any information whatsoever that was actually responsive to B or C
Give me a minute.
in those interrogatories. So prior warnings and the nature of description, the name, address, and telephone, the means by which defendants contend such warnings were transmitted. The defendants just say they were unaware of any hazards, however, wet floor caution signs were in place prior to the incident. Well, I don't have any proof that they were there prior to the incident. What I have is photographs that show they were in place after she fell, and a statement about surveillance footage that I don't see the cones and certainly don't show them from my view of things. So do they have any documentation or evidence, and who would testify to those things about prior warnings about a hazard?
So there's a photograph showing cones in place while the plaintiff is lying on the floor, correct?
Correct.
And have you learned who placed those cones?
No.
So you don't know if someone from Bed Bath & Beyond placed the cones or if someone from the mall placed the cones. You only know that there are cones that are there.
right after she's on the ground. That's correct.
Right.
And as part of this motion, the 2 photographs that were produced show the wet floor cones in different places as well. So they were moved at some point while she was on the ground. So I have a right to know who moved those, when they were moved, when they were put in place. And this is one of the issues that kind of goes back to the surveillance footage. If we had surveillance footage from the whole day, we would know these things. But I think these answers to interrogatories aren't responsive in that they don't identify who these people were. Do I need to depose every single person at the mall to find out who may have put them there?
If Mr. Williams, if the defendant knows who placed the warnings, who touched them, you should tell. You should supplement your response with the name, address, and telephone number of who those people are. If you don't know who they are, that's an appropriate response. Clearly, there were caution signs there, as we can see from the photographs. If you have control over who placed those caution signs, you need to disclose that information so Mr. Jennings knows who he should be deposing.
Fair enough, Your Honor.
Number 3 asks for information that the defendants may have with regard to whether or not this condition was open and obvious. And again, we ask for specific information about who may have seen this, who has this knowledge, who is actually aware of this open and obvious condition. And the defendants responded, defendants maintain that the alleged condition was open and obvious, not unreasonably dangerous and avoidable. Defendants will rely upon testimony and other information gathered during discovery. Well, what other information and what individuals had that information that show that this condition was open and obvious? I mean, we've been in this litigation for a while, and outside of the plaintiff's testimony that I'm sure Mr. Williams will reference in a second, nobody else from the mall has said that they inspected the area or that there was an open and obvious condition or anything of that nature. I have a right to know who that is so I can go depose them and talk to them.
I think that's fair.
On that issue, Your Honor, if I may briefly respond, as everyone here knows, that's an objective issue for the court, whether or not a condition is open and obvious. It's not subjective. Be that as it may, what we now have by way of the record is a video. What I view on that video, what Mr. Jennings may view on that video, Your Honor, or a fact finder, that may all differ as to what we perceive on the video. However, we do have plaintiff's deposition testimony. And without going through each and every admission that she made under oath, her testimony absolutely, supports that discovery response, that the condition was avoidable. She didn't have to go to the mall that day. No one forced her to. There were other entrances available. She picked this entrance because it was more convenient. Doesn't know what the hazard was, how big, how large, could she step over it, around it, whether it was wet, whether there was a hazard, whether there was moisture on the bottom of her flip-flop when she stepped down, which caused her to slip because there was precipitation outside. All of that's in her deposition transcript, but the open and obvious issue is an objective one. And I believe that there's sufficient information in the record, I know, in fact, to support that defense. So,
well, that isn't the question, though. The question is particularly the identification of persons who have knowledge as to whether or not it was open and obvious. If you are aware of such persons, you need to be disclosing that. All you say is you'll rely on testimony. I think this
plaintiff and Alfie Kane, Your Honor.
Pardon?
Plaintiff has testified in support of that as one individual. Alfie Kane, if and when his deposition is noticed, will testify similarly in that regard.
Then I would assume that he should have been identified in answer to this interrogatory. So you need to supplement that response with whatever information you've got now.
Interrogatory number 6, Your Honor. Please describe the physical condition of the premises of the area and incident. On the first occasion, the defendants inspected it following the occasion. and the defendants talk about what Mr. Kane did prior to the incident. I want to know what happened after the incident. And interrogatory number 6 talks about what happened following the occurrence, and the defendant stated that it was inspected roughly at 10 a.m. and 10:45 a.m. Well, that's prior to the incident. I'm asking about what happened after and who inspected it, what they saw.
At what time was the incident?
She fell around 11:12 or so, according to the video timestamp anyways. So I believe that the mall opened that day at 11. I could be wrong. I think they had shortened hours because of COVID-19. So interrogatory number 6 is asking what somebody from the mall first saw when they inspected it after the incident. And this response from the defendants only talks about what they saw prior to the incident.
Your Honor, I don't have an issue with supplementing that if we need to. That's not an issue.
Okay, let's do that.
Thank you.
Moving to interrogatory number 11.
Okay.
Part of this is they identified individuals who may have inspected the area: Alfie Kane, Erica Neese, Shaikayla LaPierre. But they don't provide specific times of when they did this. They provide general job descriptions and duties. So for instance, Shaikayla LaPierre is the morning housekeeper, and her job is to take out trash, dry mop, cleaning glass, cleaning bathrooms. But I want to know when these things happened prior to the incident, not just that they happened on some days, but not all days. Now, if they don't know that information, then there's nothing I can do about it. But if they do know that information and they have certain information that documents when the floor scrubber was, or the floor scrubbing machine was used, when they cleaned up the dust, dirt, debris, when they took out the trash, when they did dry mopping, those things are important to establishing that they may have created a hazardous condition by not mopping the floors properly.
I think there were other questions regarding maintenance logs and record keeping. And I believe, if memory serves me correctly, that the response is they don't have logs detailing that specific information. Okay. Therefore, the discovery responses are based upon personal knowledge and observation of Alfie Kane. If they don't have maintenance records that says we took out the trash at this, on this date at this time, there's nothing you can do about it. And I believe that there were interrogatories and responses that spoke to the maintenance of records, which would address that issue.
But I think that the bigger issue here, Javon, is the request is seeking what information or what was discovered during the inspections when they were doing those jobs. So you describing their general job duties doesn't tell me what they saw on that inspection on that morning.
Well, but a prior
I think Alfie Kane does address that. Sorry, Judge.
A prior answer told you that. The physical condition was inspected by Alfie Kane and the area was dry and clean. Condition was acceptable to receive customers for the day. Inspected roughly 10 a.m. and again at 10:45 a.m. Doesn't that answer? I realize it's not in this place, but doesn't that answer it?
Well, so do Erica Neese and Shaikayla LaPierre have similar information, or are they just absolved from providing what they saw during the inspection? I mean, you've indicated that they had job duties that day and that they were there and they did an inspection. Well, what did their inspection reveal? I'm entitled to know that before I go and depose them.
Well, Alfie Kane is the individual that attests to the discovery responses, and that the responses are based upon his, as a representative of the company, his observations and personal knowledge.
So
he can't speak for what he can't speak to what someone else may have observed but not recorded on that date. I mean, you have their information, their names at least. I think depositions can
I think you're obligated to ask employees of the mall, when did you inspect it? If they know. And what did you see when you inspected it? I think that's a fair request so that Mr. Jennings doesn't have to go on a fishing expedition and depose every employee of the mall. Those who are identified as having inspected it, he can decide whether or not he wants to depose them. I think you need to supplement your response to number 11.
Fair enough.
Right, the last one is interrogatory number 12. And this is, it's similar to the issue that we just discussed. Talks about the procedures, the inspections that were done. So they talk about general things again. The conditions vary, sometimes dirt, sometimes dust, mud, or food spills. Well, were any of those things present on the day of this incident, or were all of them present, or were none of them present? I mean, talking about things that happen in a mall on any given day doesn't help me narrow down what the conditions may have been on the date of loss. So, I mean, either
To that I respond. Oh, go ahead.
I was just going to say, I mean, either I can say that any of those conditions existed based upon this response, or I'm entitled to know what those conditions were. Which ones of which dust, dirt, mud, food spills, which one of those was present?
Or Alfie Kane's prior response as
Hold on a minute.
alluded.
Let me read
Okay.
it. All right, so Mr. Kane does respond by saying conditions at inspection on each of the identified days, always clean and customer ready. By the time I arrived, the floors have been clean, dried, and presentable to the customer. As to Eric and Nice, who apparently is the only other person responsible for inspecting and cleaning, there really isn't anything other than a general response. So if Ms. Nice has specific information as to the condition of the floors on any of those days, it needs to be provided. And he knows whether or not he needs to depose her. My guess is she's not going to have a clue.
Well, but it'll save me from taking a deposition I don't need to.
Judge, from memory, don't quote me on this, but one or more of those identified individuals may no longer be employed by the mall. I've got another case very similar to this. That may be, but I don't want, Chris, you to be surprised if that's true, that one or more of those individuals outside of Alfie Kane are no longer employed, and therefore I don't control them. Not sure that that's the case, but I do have another one that's very similar. But I don't have an issue with attempting to find out if Erica Needs has more specific responsive information to number 12.
All right, that's all the discovery, I guess, responses.
All right, so supplement those that I've indicated. Mr. Williams?
Sure, Your Honor. So part of our response actually takes all of this a step farther. And there are very specific averments and allegations within this complaint that are thrown towards my clients, specifically identified paragraphs 9 through 14 of plaintiff's complaint. And based upon plaintiff's sworn undisputed testimony, Judge, paragraphs 9 through 14 of her complaint are flawed. She has no evidence to support any of those things. And part of our response was also a request that those paragraphs of her complaint be stricken based upon her testimony because they're outright false.
Well, it sounds to me like that's more a matter for a dispositive motion, Mr. Williams.
Fair enough.
All right, thank you, gentlemen.
Thank you.
You'll submit an order. How much time do you want to supplement? Is 14 days sufficient?
14 days from entry of the order. Sure. Chris, are you going to send over a copy of the proposed order for my review?
Yeah, I mean, if you want 21, I mean, it doesn't matter. We can do 21 if that's easier for you, but.
I mean, yeah, we got a holiday coming up. That's fine. I just want to review it before it's actually presented to Your Honor to make sure we're talking about the same.
Sure. 21 days from entry of the order.
Okay.
All right, I'll watch for that order.
Have a good weekend, Javon.
Thank you. Bye,
Have a
Judge.
good day.
Do you have it full docket like the last time I was here?
That was